I'm so excited to be here, and I'm very honored that Matt and Donna invited me to present. So thank you to both of you and to all of you for enduring a long presentation that's going to come up, 45 minutes on Creative Commons and copyright too. So I hope you had some sugar because you're going to need it. But I'm going to try and make this as entertaining as possible, as entertaining as copyright can get. But it's going to be a challenge. So. As one said, my title is Scholarly Communications and Copyright Librarian, so I help a lot of people on the U of U campus answer their publishing and copyright related questions. And from what you all have described about your projects and the videos that you are creating, I think you probably have a lot of copyright questions too. So I think I am here to help you and answer your questions, and this will be a good collaboration and partnership. I want to start by pointing out two resources that I hope will be of use to you as you embark on your projects, and I've listed the URLs here. The bottom one's getting a little cut off there, but the two URLs, the first one will take you to a research guide on how to find permission-free resources. So different types of content that have a Creative Commons license, which I'll get into in a minute. And then the second one really goes over a lot of detail about copyright for those that are either digitizing stuff or using original content from somewhere else that you yourselves have not created. In fact, the bottom link is the outcome of a project that Cheryl and Sandra and I worked on as part of that, one of those task forces that Sandra mentioned. So just jot those down now if you can. I think Donna's also added them to the Canvas course, and I'll also have them listed at the end of the presentation too. So you'll catch that bottom one that's cut off there. Okay, so I'm going to start off with Creative Commons and then I'll get into copyright in general. But Creative Commons was started by a person named Lawrence Lessig and others. It was a partnership. Anybody ever heard of Lawrence Lessig? I bet the Creative Commons group has, yes. Anybody ever read Free Culture? Some of you, excellent, great. I have a copy with me here, and agree with me or disagree with me, those that have read it, it seems like he really focuses on the distinction between commercial culture and non-commercial culture, and the way that law and technology has treated those two different entities. So, you know, Disney movies, very much a commercial culture. Storytelling, face-to-face conversation, non-commercial culture. And that, and before the internet, was not always captured. So it had its own way of getting transmitted from people to people. The laws didn't really come to control it in the way it does now in terms of it being distributed on the internet. So I thought that I would just read from you a really brief paragraph just to kind of give you a sense of where he is coming from in terms of this commercial and non-commercial. So he says, this rough divide between the free and the controlled has now been erased. The internet has set the stage for this erasure, and pushed by big media, the law has now affected it. For the first time in our tradition, the ordinary ways in which individuals create and share culture fall within the reach of the regulation of the law, which has expanded to draw within its control a vast amount of culture and creativity that it never reached before. The technology that preserved the balance of our history between uses of our culture that were free and uses of our culture that were only upon permission has been undone. The consequence is that we are less and less a free culture, more and more a permission culture. So I don't know if any of you agree with that, if you feel that you've come up against that in any sort of way, but that was really a big impetus behind creating Creative Commons. So I heard that you all have now learned how to enjoy ambiguity. Yes? Excellent, because you're gonna have to really appreciate it when you get into copyright and when you get into Creative Commons. Okay, hopefully Creative Commons is a tool to deal with the ambiguity. So that's the air system? Okay. All right, so Lessig's really big argument is that the terms around copyright keep getting longer and longer and longer. So this free culture is getting smaller and smaller and smaller. So this is just a really quick rundown of how long copyright terms have lasted during different ranges of our US history. So in one of the first copyright laws the term lasted for 14 years. So authors could enjoy their exclusive rights for 14 years. 1831, you can see there was 28 years with a possible extension. By the time we get to 1998, the most recent change, this is with the Sonny Bono Act, it's life of the author plus 70 years. So anything that you all are creating, in fact, you all are creating a lot just right now. The notes that you're taking on your computer, anything that you're writing, it's yours. And it's yours for your life plus 70 years. So most anything created in this room today is probably protected until 2120. If we say the average lifespan is 80 years or something like that. So things get protected for a really long time, and Lessig is saying that we need to find a way to balance the fact that the law protects things for so long. Okay, so the other contention that he has, and the reason he started Creative Commons, was because of not only these term extensions in the Sonny Bono Act, but the Digital Millennium Copyright Act, which I'm sure many of you have heard of. The DMCA is what a lot of people refer to it as. It's kind of got these two parts to it that a lot of people disagree with, because it protects the technology and the delivery mechanism plus the intellectual properties. So it makes it illegal to circumvent the thing that the media is getting, that the content's getting delivered on, plus then you have to deal with copyright law on top of that in terms of the intellectual property. So if anybody's got a DVD or something, or even if you've got like a file that you have pulled from the internet, there's probably some sort of digital rights management around that file. Like, anybody ever downloaded an ebook? Like an Adobe Editions ebook? Have you ever tried to do anything with that file other than read it? Have you ever tried to copy and paste, or anybody ever had success? No, so that's the DRM that's around the file, and it controls you as an end user, your ability to get in there and get to the content other than just by reading it with your eyeballs. So Lessig has major issues with the DMCA. And so that on top of the term extensions, he sees this as a kind of, unnatural shrinking of the public domain and this free culture. And he calls it the public domain squeeze. And he thinks it's really bad timing because while we have these two elements of term extension and DMCA, we also have this new technology and this new culture, which is creating an explosion of information. And it's really easy to distribute information now. And these two are just not working together. They're sort of at odds with each other. And you all are going to come across this in the projects that you are working on and what you want to distribute and the types of content that you want to use. So he founded it in 2001 as a nonprofit, and it has a board of directors. Most of them have some sort of legal background, but they don't provide legal advice. And then they are housed primarily in San Francisco, but they have a couple of other offices too. I think one in Boston.
Because he moved to Harvard from Stanford. So
yeah, that's right, yes. Okay, so there's the quick rundown, kind of the quick background. And basically, it's a mechanism for licensing your work. And this will make sense when I start explaining what copyright is and isn't, which many of you might already know. But it's a way for you as a rights holder to say what others can do with your work. So if I just want to be attributed, so in fact, my PowerPoint, my presentation has a Creative Commons attribution license. So you all are free to redistribute this and make a copy of this and adapt it as long as you give me credit for the original, as being the original creator. But there are other licenses and restrictions and components that you can add. So if you don't want someone to reuse your work in a commercial setting, then you can put that type of restriction. Or if you don't want anybody to create a derivative work, you can say that as well. And kind of the most controlling, I guess some people have said, is the share alike license, where you basically say, I want you as the next user of my work to use the same license that I have used. So it kind of perpetuates itself, and then it opens up this content and this culture just by virtue of you saying that the next person has to be share alike. So some people have issue with that last one, but we can kind of talk about those details. And then at lunch, we were talking about the CC0. It's a declaration, so it's not one of the licenses that you can choose, but there is wording where you can say, I am dedicating this to the public domain, and I am waiving my legal rights that I have in this work. So I didn't put that here since it's not one of their, stated licenses. Okay, so we can't talk about Creative Commons without also talking about copyright. So what kind of sense do you have? We had a lot of conversations at lunch about what copyright even is or not. So anybody have a good sense of what it is? And please feel free to read from the slide. How would you describe copyright? Yes?
Copyright is a system of incentivization so that we have reasons to create
Yes?
and to share and to do all these things.
Okay, very good. Yes, so it's...
For protection too, of course, but it really comes back. Because copyright is a very, just like libraries are a unique system that really came out of the United States and democracy.
Right. Mm-hmm.
It's heavily about incentivization for the betterment of culture and society.
Yes, that is a very eloquent way of putting it.
It's changed a little, but...
Yes. So the constitutional purpose, it is in the Constitution besides being statute and law. And the purpose stated in the Constitution is to promote the sciences and the useful arts. So that's sort of the big overarching goal of copyright, which I think you really pointed out very well. And then the law basically makes it a legal right. So us all as American US citizens and as original creators of content, we have legal rights to the material that we create and produce. And it is automatic. And this is actually one thing that I think Lawrence Lessig might disagree with. I'm not totally sure because it's a pretty big change in the most recent law. In the 1976 law, it used to be that you had to put that little copyright symbol and a year and your name, and then you had to register, and that's how you got a copyright. But now, whatever you all are creating on your laptops, it is automatically yours without you having to do anything. So it's hard. So those that work in special collections, it's, we don't really know. If you don't have any idea who registered the rights or who created the work, you're not going to have any idea who the rights holder is. So it's good if you're a creator, maybe not so good if you are working in a library. All right, it does have to be fixed in a tangible medium. So the hard drives on your computers, that's the thing that serves as the fixing the content, or a piece of paper if you're writing on something. So there are some criteria, and it has to be slightly creative too. And we'll get into this. It has to have some originality to it. So the creator is the owner, this is good news for the most part, unless it's a work for hire. So those of you doing the Creative Commons project and getting content from different libraries, you're probably going to run into this aspect of the law quite a bit, because if you are getting content from people who are employed somewhere, they might not be able to claim that they are a rights holder and an original creator because they're working for some other entity. So you just have to be mindful of that. And yes, Matt, please.
You may be going to talk about this soon, but the government employee piece of that may already make it so that we're in the public domain.
Yes, federal government employees, yes, definitely.
Federal, not state?
Public domain. State, I'm a little unclear on. There are copyright rules at our state level, and I'm pretty sure state employee created content is public domain, but I'm not totally certain based on our laws. I wish Ray Matthews were, he might know more than I do. But the other good thing, I guess, or potentially confusing thing, is that these rights can be transferred, and I'll show you what the rights are in just a minute. So again, another issue for special collections or anyone doing any kind of provenance research. Okay, you may have a creator and that person is listed, but there is potential that those rights were transferred to some other entity. So if I'm writing a book and I've got my manuscript and I submit my manuscript to a publisher, then I'm probably going to sign some sort of transfer agreement with that publisher. And then that person becomes the rights holder. And even though I'm the writer, I'm no longer the person who gets to decide what happens with my work. Okay, so there are 5 rights. They're really easy to remember. And if you can sear them into your brain, it will make your life a lot easier when you're trying to work on your projects. The exceptions to these rights are much more complicated and not as easy to remember, but if you can at least remember the 5 rights, you'll be great. All right, so, and I'm going to give you a test at the end, so pay attention. All right, the first one is obvious. It's the right to make a copy. The second one is to do an adaptation, prepare derivative work. Third is to distribute copies of a work. Fourth, perform a work, a play, piece of music, and then display. So copy, distribute, adapt, perform, display are the 5 rights. Any questions? And these are exclusive rights to for the person that is the original creator. And that person gets to decide how his or her work and how he or she engages in these activities. And those rights rest solely with that person. So who's taking notes? Up here at the front, Julianne. Yes. You are the owner of your notes that you are creating. So you are the person who gets to decide how and when it gets copied, how or when it gets distributed and displayed, and if anybody makes a change to it. You are the decider. But there are exceptions to these 5 exclusive rights. So sorry, I will get into those. So so you can transfer these rights either in whole or in part, and this is another slightly tricky thing. So, okay, if you can copy, distribute, display, adapt, and perform, any one of those you can transfer to somebody else, and it doesn't have to be all 5. If Julianne wants to just give permission for Aaron, yes? For Aaron to copy, she can give just that one right over to Aaron. And then you would have, say, if you did it in writing and there was, something signed, then Aaron would get to decide how your notes get copied. But then if you want to retain your right to decide how it gets distributed and displayed and adapted, you would still hold those rights. So these can be broken apart. So you have to kind of keep track of them, and you have to think about, if you're using someone else's work, where these rights might reside, and it can get really tricky really fast. Okay. All right, so the rights last a really long time, like you saw in the Lessig that he has argued. It's life of the author plus 70 years. And if it's work for hire, it's 95 years. So if you are pulling content from somebody who's employed by somebody else, then those rights you can probably estimate for going 95 years forward. The public domain is generally any work created before 1923. So there is some hope there. I mean, it's pretty clear lines. Anything older than that is public domain. There's some gray area between 1923 and about 1960, where a lot of it's in the public domain, and I'll show you how to figure that out. But then anything after, like 1976, that's life of the author plus 70. Okay, so the limitations that I was getting to before on those exclusive rights that Julianne has. There's a lot of them, but the biggies are fair use. There's a fair use doctrine that's part of the law. And then there's some educational exceptions which might or might not apply to the projects that you guys are all working on. So fair use is the biggie, and I'll focus the most on that one, but I just wanted to mention some of the educational ones since a lot of you might work in educational institutions and these might just be good to know about. So there's sometimes some confusion about the big fair use doctrine and these educational fair use guidelines. So I don't know how many of you have ever heard about like the 10% rule. That usually is what comes from the fair use guidelines. And a lot of universities adopt that as their policy if you happen to work at any sort of like school or higher ed institution. But that 10% amount isn't really part of the law. It's not written down anywhere. So if you are outside of an educational institution and with your projects, if they're not tied and you're not having to follow some university policy, then you don't have to worry about 10% so much as a limitation and as a number. And I think you guys might have a lot of flexibility in that respect, since you're sort of your own group, and you're working as part of this grant, but you're not having to follow any sort of employee policy. And then the other biggies, if you're doing any kind of face-to-face teaching, like if I were to show a full movie during this face-to-face teaching session, I would have an exception in the law to do that. And there are others too. For distance education, there's the TEACH Act. And then there are some professors who can circumvent as a category, professors as a category that can circumvent the DRM that's part of the Digital Millennium Copyright Act. So just some exceptions to be aware of. Okay, so the big fair use doctrine. I'm sure all have heard about fair use. Yes, very good, great. And I think you can probably all rely on it quite a bit in the projects that you're working on. So the three areas that most courts consider to not be an infringement when you use someone else's work are these three bullets here. If you're using someone else's copyrighted work for purposes of criticism or comment or news reporting, you guys might get into the criticism and comment area. If you're doing it for teaching or for research or for scholarship, then those kind of get protected, those types of activities, when you're using someone else's work. So I could maybe argue if after Aaron had the rights to make a copy, then I could maybe argue a fair use of Julianne's notes if I were providing commentary or some sort of scholarly or research or satire, yeah. So fair use was really, it's an important doctrine because it helps balance the fact that we have free speech and with the fact that rights holders have this monopoly. So rights holders can't have too much power or else we would not have any kind of culture or discussion or, progression of knowledge in the country. So fair use kind of helps balance that. Okay, but there are 4 things to consider, and I know this is a lot of information and it's hard to keep track of all this, and there are a lot of great tools to help you with these types of evaluations so that you don't have to remember all of these exceptions. But you have to think about the purpose and the character of your own use. How much is it parody or satire? How much of it is commercial reuse? How much of it is educational, that type of thing. And then what the nature of the work is that you are using. And I think for a lot of your projects, maybe with your author's project, there might be a lot of highly creative works, and those tend to receive more protection. But for some of the Highway 89 stuff, that might be much more fact-based and almost documentary type of work. And those a lot of courts have given a lot of leeway around the reuse of that type of material. And then how much you use is really important. So I mentioned the 10%, but there's nothing in the fair use doctrine that says 10%. It really depends on these other factors and your own use. And the biggest factor it seems like the courts always focus on is how you affect the potential market for the work. So if you happen to copy the full work and then that full copy replaces the ability of someone to purchase the original, like if you can get to the full work for free instead of going to purchase the original, that would be a major effect on the market. If you have introduced this new version and this new copy that takes away from the other version. So, does that make sense? Fair use? Okay, great. All right, so a basic rundown is that basically that authors and creators are the rights holders originally, and for the most part, but these can be transferred or they can be licensed to other entities other than themselves, and that those exclusive rights allow them to determine reuse of their original content. So you all are really, you're kind of working in both worlds because you are creating something original. So the videos that you're going to create about your projects, you as a group are co-owners in that video. But you're using other people's work. So then you have to think about how and why you are reusing other people's works, which is where the rights for readers and for users come in. So fair use and other limitations are going to give you usage rights. But if those limitations don't apply to your reuse, then that's where permission comes in. And so even though Lessig feels that we are in a permission overly, you have to ask permission too often, that still is our law, and that still is the exclusive rights that creators have. I'm going to run into a rundown next, the types of works that are protected, and then we'll get into some of the terms of licenses themselves and how you can find works that have these Creative Commons licenses so that you're not always having to think about, do I need to get permission? Can I rely on fair use? There are ways to kind of get around those requirements. Okay, so any sort of work of authorship that's fixed in a tangible medium, like I said, it's an original work and it's minimally creative, those are what are eligible for protection. And these are just some brief examples of things that are protected. So different books and writings and music and photographs. We were talking about photographs at lunch too, those are copyrightable. Databases, the structure around data, that is protected. Maps are protected, artwork, movies, of course, software, of course, is always protected. Sound recordings. Pantomimes always get me because it's not fixed in a tangible medium, but they are protected. And then drawings and blueprints are also protected. So, this is a lot of content. It's almost everything you guys are probably going to run into in your projects. There's not much left that's not protected, but there are some things. And those happen to be works created by US government employees, ideas, and facts. But there's a lot that can fall under these categories too. So like Sandra was saying before, can you borrow someone's idea? Yeah, actually you can, because ideas can't be protected. There's no legal entity in our country that locks down ideas. But the expression of that idea is what gets protected. But there's a difference between the idea of a table and the expression of a table, right? So this design of these tables is probably protected either through copyright design or some sort of trademark or some sort of patent. But the idea that tables can exist and be built in different styles, that can never be protected. So you have that to rely on, and basic facts. So 2 + 2, that will never be copyrighted. Short phrases, sometimes they can be trademarked, but short phrases can't be copyrighted. All right, so there is a public domain, and that is a type of resource that you all can rely on. And there are a lot of creative works out there that are not currently protected by copyright law. So either they were published before there was copyright, the copyright has expired, or it was never acquired, or the owner, like we were talking about, dedicated it from the outset to the public domain, or it was not even eligible for copyright protection to begin with. And someone once said, what is his name? Krasilovsky, he said the public domain is like a vast national park without a guide for the lost traveler and without clearly defined roads or borders. So it's out there, it's messy, and it's possible to find stuff, and I'm going to show you some of those tools coming up, and Creative Commons definitely helps. And but there are some resources there. If you're trying to figure out, this is another thing we were talking about at lunch, whether or not something is in the public domain, there are some very basic guidelines that you can follow. So like I said, any sort of work published before 1923 if it's a US government or not a US government work, that's gonna help you figure that out. And then what the publication status is it, say it's already currently easily available to the general public, it might not be in the public domain. And then you have to kind of do some math. And it took me forever to figure this out. Okay, so I've been in this job for like 5 years. And actually figuring out when a work enters the public domain is harder than you might ever imagine. So you have to figure out the year of publication, and then you have to figure out the average life expectancy, and then you have to subtract the age of the person at the point when he or she published, and then you have to add in the copyright duration at the time. So right now it's life of the author plus 70. So, okay, a work written in 1998 will enter the public domain in 2116. So you have to kind of, okay, so we were talking about Ansel Adams during lunch, and I looked it up during the break. So the National Park Service commissioned him to take photographs in 1941. And commissioned works are not always considered government works, so sometimes they just don't automatically enter the public domain. But what we could do is this little bit of math of, assuming that there is some sort of right around Ansel Adams photos, we could try and figure out, we know that they were published in 1941, we probably know when he died at least, and then try and figure out whether or not those photos are in the public domain. So that's one tool to rely on. There's this other really cool tool called the digital slider, and it's developed by the American Library Association. So it will allow you, there's this cool little arrow, and you can move it depending on the year that the item was published and the rules at the time. It will tell you whether or not it's in the public domain. So if the math just gives you too much of a headache, then you can use the slider. And it's referenced here, of course, and then also in the Copyright for Digitizers handout. So one thing you have to be careful of is copy fraud. And I brought this up during lunch also because Marriott Library, and I'm just gonna say this publicly, is probably one of the worst violators of copy fraud. So what you'll run into quite a bit is somebody taking something from the public domain and then claiming that they are the rights holder to that item, which is not true. Okay, so this is Little Women, which was originally published when? Anybody remember? Okay, 1868. So what's the rule on public domain?
23.
Yeah, okay, so this is in the public domain, yes.
Yes, but they're not claiming the rights to the words, they're claiming the rights to the formatting.
Ooh.
And that's the big difference. You could copy down everything that Penguin has written word for word, but like you can't take their fonts and reproduce it in the exact same package.
Ooh, that's a very interesting distinction. Okay, so they have got their little copyright symbol for Viking. They say 1989. Once something has entered the public domain, it's always in the public domain. So Little Women, yes, public domain. Anything, and maybe this is what you're referring to, anything new that is added, if there's a new introduction, a new appendix, that new content can be copyrighted, and this is probably what they're referring to in their copyright statement, but the novel itself is not copyrightable. So this can be misleading, and don't let the copy frauders mislead you, because once it's in the public domain, it's always in the public domain.
And that's why those books, so like if you ever see these books, they always have new prologues and new like introductions. Because
right.
That means from that moment, like it's a new kind of copyright.
But just for the new work.
Yeah.
Not for the original.
Yeah, you can write down those words all you want.
Or you could even copy. So, I mean, your point about fonts and the layout. All right, so there was this court case, the Bridgman decision, in like 2000, I think, or 99. And the court kind of, I guess whatever court it was trying to address this by saying there has to be a certain amount of originality and creativity in order to claim a copyright or be eligible. And making a slavish copy of something, so if I just scan Louisa May Alcott's novel, I'm not adding anything original, I am making a slavish copy, and I do not meet the test of originality, so I'm not eligible on two fronts, really. One, it's in the public domain, and two, I have not added sufficient creativity to even be eligible. So even though a font might be an element of creativity, I think in this Bridgman decision, the court is basically saying that's not enough. That's not enough creativity. Okay, one question here, yes?
Well, I was just going to add that you have to be careful, even though, yes, let's say public domain, generally we cannot leave it, but because of our international agreements on copyright, a lot of composers ran into that issue because they started applying international copyrights to some pieces like Peter Gunn. So you can no longer, let's say, orchestra can no longer perform Peter Gunn without paying for it now, where they used to perform Peter Gunn because it was considered a domain within this country. They have now, because of our international relations and our upholding other countries' copyright rules, you can no longer perform Peter Gunn. So there are some still murky waters within what we consider public.
Yes?
Are you still taking questions? This would be fairly quick. Does this apply to scholarly articles written by government employees as well? So, for example, a USDA employee publishes something in Nature. And every version of that, even the formatted version, the official version of record that Nature publishes, that's public domain?
Yes.
Okay.
If they are a contractor of the federal government, then you have to be an actual employee of the federal government and not getting a grant from an agency. Yeah. Okay, so yes, the public domain is definitely complicated. And the international rules like the Berne Convention basically say that we will honor other people's copyright rules and authors in the same way we honor and protect our authors here. So yeah, they're cut off in years, like in the UK, I think it's life of the author plus 50 years or something. So there is, potential that then it could enter the public domain earlier in the UK, but we would still treat it according to our rules here and honor that author in the same way we would honor authors here. And most countries are members of the Berne Convention too. Okay, so in light of that, there are some good resources to help you with the public domain and how to find these types of works. Stephen Fishman has a really good book on just the topic. And then the Center for the Study of the Public Domain is a really good resource. In fact, they have a comic strip that's actually kind of entertaining if you ever want to take a look. And then I read a blog almost on a daily basis. It's Nolo's patent, copyright, and trademark blog. His name is Dear Rich Stim. He posts almost daily on different public domain and copyright matters. So this is a really good resource. All right, so if it's not in the public domain, then you think about those exclusive rights and the limitations on those rights, which of course include the big fair use doctrine and other educational exceptions. But then if those rules don't apply, then you need to get permission. And it's pretty easy, kind of easy to get permission these days, only because we have the web and it's easy to look people up and send an email. If you don't get any kind of response, then you can fall back on fair use as a defense for the fact that you made this good faith attempt. But Stanford has a really good overview of how to get permission and the types of steps that you should go through and how to document it. So this is another really good resource to consult. Okay, and lastly, how to find permission-free works. That's the very first link I gave you at the beginning of the presentation. And I'm just going to go there now so that you can see some of these works here. Okay, so Creative Commons has a really great search tool, which I think Tony Sams may have covered in his presentation. But if you wanna find Creative Commons licensed materials, this will give you a start. You can enter your search query. You can go directly to their search page though as well. But there are lots of other resources too, public domain resources like Project Gutenberg and Internet Archive that are listed here under different types. So if you want to find texts that are in the public domain, or if you want to find video, they're broken out by their content type. Okay, so if you are curious how to choose a license, a Creative Commons license, so for your videos, for example, I mean, if you as a group and as joint copyright holders, if you're interested in applying a Creative Commons license to your video, then their website has a really good tool to help you think through what type of license you want. So they ask you a few questions. Will you allow modification of your work? And this is one of the 5 rights, right? The derivative right, and you can say yes or no to that. And you can say yes as long as others share alike. That was the very last license that I showed you in that one of those first slides. And if you want to allow for commercial use of your work, you can say yes or no to that. And then it will, the license jurisdiction, I always just say US, but I suppose you could do international. I think the jurisdiction just depends on, maybe in the international context, if I had a license on my work and then it got used in the way I said it shouldn't be used in another country, then I guess if I had an international jurisdiction, then maybe my ability to sue that person who used it in the way I said I didn't want to might have better luck or something, but I never really know. So I just say US, so then it tells you which license you have selected. And then you can fill in metadata too, so this goes on the web so that when you do that Google searching and you limit it to Creative Commons, then your information is there as well. And then it gives you the code, and you can use this code if you've got a web page, or you can copy and paste the image into the file itself if you want to make it very obvious. The copyright for digitizers goes through, here, I will show you, this might be helpful. Sandra and Cheryl and I had, on the metadata task force for Mountain West Digital Library, because the software we use, sorry, this is a huge view, you can't really add that Creative Commons image in any sort of easy way. So we ended up just doing basic wording for our metadata. And I'm really sorry on the view on this. So these just go through basically everything I've done in the presentation. So you can see here, this is some example wording to use. So this is a built-in Creative Commons metadata field. So it uses the terminology of Creative Commons. So it has the personal name. So you as a group, you could list all of your names as the rights holders, and then you could list contact information. If you happen to use software that can't handle HTML or can't handle an image, then you can just basically type out the wording. And then you're specifying that use of this file is allowed according to the Creative Commons license. And then you can link to the license if you need to. If you don't use a license, for Mountain West Digital Library standards, we had a couple other types of wording. If you do want to reserve all of your rights, if you want to say that, then just say it up front. Copyright, symbol, there we go. All rights reserved, and then you can put some kind of wording around how transmission and reproduction of these materials are protected by copyright. And then you can also mention that fair use is one exception that people can rely on if they're wanting to use your work, which has all rights reserved. You can sort of guide people to fair use through your metadata. All right. So what other burning questions? I think I had planned for about 45 minutes or so of presenting, and then just the rest of the time answering your questions and maybe coming around even and going through individual questions for your projects and what you might need to look for in your projects. So we can spend the next few minutes doing that as well. So here's my contact information. If you have any questions, feel free to call or email. And then this is the link to my presentation and my license, which I know, I'm sorry you can't see. Anyway, questions?
So if you have a copy and you make a copy of the copy, should you just attribute the first copy or should you attribute the copy of the copy?
That's a good question.
Sorry.
Was anything changed?
That's where I assume would be the big difference. Because if it was changed, then you do the copy of the
You
copy.
do your whole line,
Right.
as much as you do.
Yeah, if you're trying to help someone find the thing it is that you used, then I would cite the original. Or whatever it is that you used. I mean, if you use the copy of the copy and it's easy for people to get to the copy of the copy, then sure, point them to the second copy. Yeah. Yes, Sandra.
So if the library or special collections or archives has something like photographs that were created before 1923,
Yes.
and they're digitizing them and putting them online, do they really have any basis for claiming any, or putting any rights restrictions on those digitized versions of public domain photographs?
No, they don't. So if it's older than 1923, then, and you are creating a slavish exact copy of the original, there's no new edition, then there's not a basis for copyright. If it's after 1923 and there's some sort of deed of gift or agreement that was entered into with the person, the original creator, and if there were rights that were transferred to the institution, to the library, then you could truly claim yourself as a rights holder.
One of our groups is going to be working with an index of obituary entries from newspapers. So I know with a book, you know, you can reproduce up to a chapter, 10% or something like that. What are your thoughts about how far copyright protects a single obituary entry in a newspaper, maybe from the 1950s?
Wow, that's a hard one. The person who wrote the obituary would be the rights holder, and that person may not, probably doesn't work for the newspaper, is maybe a family member or someone. So it would be probably really hard to find the rights holder and ask permission to use that full obituary. So I would say that relying on fair use and thinking about the nature of the work and the nature of your own use would be really important.
Okay, so in this case, for this particular genre of material, then the newspaper doesn't necessarily automatically hold the copyright.
If they've got some kind of agreement that people have to sign off on when they submit an obituary, then they could possibly have, rights could have been transferred from the obituary writer to the newspaper. But if they don't have any kind of agreement with the obituary writer, then I'm not sure what their basis of a copyright claim would be, unless they had a staff, you know, someone on staff who wrote the obituary.
Okay,
Matt's dying to.
Let's just talk about risk for just a minute.
Okay.
So let's say we gave it the broadest liberal interpretation, and we put something up, and later somebody comes to us and says, hey, you can't put that up there.
Mm-hmm.
We hold copyright on it.
Right.
What's the worst thing that's going to happen?
Well, they would have a basis for suing you. The important thing about fair use is being very cognizant of the fact that that is what the framework you are working within. So if you really think you have a good fair use defense, then document it and be very clear about why you think it's fair use. And then if that person who is the rights holder comes to you and disagrees with your use, then you can have an intelligent conversation with that person and say, actually, I'm relying on these fair use rights and here's why. And if the person still disagrees, then there is a legal ramification that that person can rely on.
But a lot of times, they might just tell you, I don't want that up there.
They can.
And we take it down.
That's how a lot of people will respond. But if you would prefer to not take it down, then you need to have a pretty good basis of why you're not going to do that. Donna.
That fair use evaluator that you showed us.
Yes.
I thought it was really helpful, and I use that with faculty when they want to evaluate their risks.
Okay.
So if you could show them
I
that,
can,
that would be helpful.
absolutely. Yes, so what Donna is referring to is another really great tool that is developed by the American Library Association, and it's called the Fair Use Evaluator. And it basically goes through those 4 factors that we looked at: the nature of the work and your use, and effect on the market and amount. So it's a kind of just a little click-through tool that helps you analyze and be able to describe why you think something is fair. And I'm just going to click through a couple of this. First screen just gives you the context of who you are and what the published status of the work is that you're using. And then basically it just goes factor by factor into purpose and nature. And the really cool thing is this little cheat sheet to get help in describing this. It lists the factors that favor fair use and those that oppose fair use. And you can just paste these in. So in your case, a lot of you are doing transformative type work. So, like this one is probably a pretty common theme for all of you. So you can paste that in, and that becomes an element of this whole evaluation. And then you kind of weigh where you think it fits on the scale of fair to infringing. And if most of your boxes are positive, then you're probably on the fair end of fair use. If you've got some negatives in there, then you might be closer to infringing, but then it does an overall average of what you have selected. And then I'm moving quickly through this. And then at the end, you say generally what you think the level of fairness is based on all of those factors. And then it generates a PDF that then you have for your records. So if you get someone who sends you cease and desist or an email that says, please stop, then you can talk to that person about fair use and show them your lovely PDF. Okay, Matt, I know you had a question.
I was just going to ask whether for that project that Cheryl was referring to, if Section 108 gives them an additional, reproduction of libraries and archives, an additional protection for the obituaries.
Possibly. Okay, so Section 108 is actually an exception I didn't even cover, and that was horrible of me to not cover it. So libraries can copy and distribute under certain rules. So if a book or an item is lost or stolen or damaged or deteriorating, then a library is allowed to make up to 3 copies of that item, and full copies is allowed. And then the distribution has to be restricted to the physical equivalent of the library. So if you decide to make a digital copy to replace the damaged version, then that access to the digital copy has to be IP restricted, basically. So in Cheryl's case, if she is interested in making a publicly accessible online collection, the library and archives exemption wouldn't really come into play One, because she's not anticipating or isn't replacing something that's lost, damaged, or stolen. She's creating a collection, yes. And if she wants it to go beyond the physical boundaries of the library, then she will not meet those two components of Section 108.
Obsolete too, right?
And obsolete, yes, that's the other biggie, right? Yeah, so like Betamax and, yeah,
Microfilm.
yes.
I'm just gonna, I can talk loud. So this is the project with the index.
Okay.
It's an obituary index that it was made sometime after 1970.
Okay.
It has 0 copyright claims.
Okay.
Of where it came from.
Who created the index?
I have no idea. Do you guys know? Yeah.
I think it may have been the Utah Genealogical Society,
Hmm.
which had affiliations with the LDS Church, but I'm not.
Okay.
So there's no marking on the index at all.
Wow.
anywhere.
Okay.
So I had sort of assumed it was an orphan work.
Possibly, yes. Uh-huh.
So I was just sort of, feel that out.
Okay, so that's a very good question. One of the other tools that I didn't show you, I sort of thought I was going to be overwhelming you guys, but I should have included more. Let's see. Marriott Library has a copyright overview page, which I maintain. So I add resources to this all the time. So from our homepage, under research tools, there's a page called Copyright Overview and Resources. And it basically just gives you the rundown that I have just gone over, goes through the exceptions. And then it also gives ways of trying to figure out who a rights holder is. So there's the Library of Congress's, the US Copyright Office / Library of Congress catalog of copyright registration records. And sometimes you can find, if someone has sent a copyright registration, you can figure it out who the rights holder is and when they submitted their registration. So if there's no marking, though, about who the potential creator is.
Or even like an official title.
Yeah, there's not even an official title?
No.
Yeah. Okay, well, you could do your due diligence and do some basic keyword searching and just see if there's any registration records. And so this is one tool. This only covers registration records from 1978 to the present. So this was 1960.
It was made sometime after 1970.
Okay, so if there is a registration record, it will be in here. And if nothing shows up here, then yeah, you could probably consider it an orphan work, but there's no rules around orphan works other than fair use and other exceptions. Yeah. But fair use would definitely be way in your favor because one, you don't know who to contact to get permission, and that's a big piece of the analysis. And your use probably wouldn't harm the market.
Right.
If there's no way to even purchase or find out who created it, then there's really no market for it. Okay, other questions? Very good. So I've got a couple of business cards. If there are certain projects that you feel like you're going to need a lot of copyright, working through a lot of copyright problems on, then you can always feel free to email me, and I've got them in the back at the table. Yes?
Sorry.
No, it's fine.
Question about video clips.
Yeah.
Is there like a 10-second rule to be able to use certain video clips?
Uh-huh.
Educational. Can you explain the usage of video clips
Sure.
for educational purposes?
For educational purposes, yeah. Okay, so that 10% rule that gets referenced all the time is the Educational Fair Use Guidelines. So if you are on a campus, may I ask which campus? Any. Okay, so if you're at the U of U, we use the Educational Fair Use Guidelines as our copying policy, and we follow the 10% rule. So for a video, we would only, if we couldn't buy permission to copy that video, then we would rely on the 10% rule to copy that clip. So 10% of a 2-hour video, an hour video is only going to be, 6 minutes?
10%
Yeah, 10%. But so, and that's just the educational fair use guidelines. They're really, really narrow. And they really only apply, the stakeholders who got involved and all agreed to it were like some professors and some librarians and some publishers back in 1976. So they're really outdated, and they're really just, they were kind of trying to get a handle on what higher education institutions were doing in terms of how much they were copying and not paying for. So they really just apply to that type of setting, and it's not the big fair use doctrine. It's really very small compared to the big fair use doctrine. That amount is important in the big fair use doctrine, but there's no strict limitation on amount. There's nowhere that says you can only use 10% and claim fair use in the big doctrine. Yeah. Yes.
This is all very interesting to me, so I'm glad you just said that last piece, because the 10% is not in law anywhere.
Yeah.
It's just that a bunch of people
Yeah.
decided to agree to that.
Right.
But we're taking it to court, and it depends on the scope and nature of the news. 5 seconds could be too much if it was
Sure.
the most important piece of the work.
Sure.
Or you could use an hour and a half of it if it was just someone droning on and on and on about their bicycle.
Right. Well, so that's what happened in the Georgia State case, which was a higher ed copyright lawsuit. And the judge really referred to the 10% rule in her opinion. I mean, she really focused on the 10%. So yeah, it's not, well, no, because it's still not part of the law, but now we've got this opinion.
She's setting precedent.
Yes, and now higher ed institutions are sort of scrambling to make sure that we're within this 10%, and at least, but the other big piece of the opinion was that that people were doing some sort of documentation around fair use. So if in the case someone does go beyond the 10%, at least we have some kind of evidence and record of why that person did that.
So that documentation is extremely important.
Yeah, very, yeah, yeah.
So in the case of the obituaries,
Yeah.
is, I guess, documentation of your
Yeah.
due diligence.
I think so. I mean, it's potentially an orphan work, still potentially maybe in the public domain. If we can find out an exact year that it was actually published, and if it didn't meet the requirements, then it could be in the public domain.
Yeah, but I need to clarify for this obituary project that we're actually talking about 2 layers of copyright. First, we're talking about the original index, which is what Brooke mentioned.
Mm-hmm.
People put this index together, and that might potentially have copyright ramifications.
Yes, right.
Then, as part of their project, they may get to a point where they're trying to actually present the full text of each
Obituary.
that is indexed by this index. And so that's a whole different layer of copyright. And that's
Mhm.
what I was asking about.
Mhm.
So we've got 2 different issues.
Yeah. Yeah, so there is compilation copyright, and I think maybe that's the 2 layers you guys are dealing with, where you have a collection of individual copyrighted items, which you're going to do some sort of activity around, either copying, distributing, or displaying. And then you've got the index, which has compiled all of those. So whoever compiled them probably or potentially could have a right in the compilation and the way they organize the index. Yeah, so I see your point. You've got basically individual rights holders and individual items. But I think doing your due diligence and then a fair use analysis would really help you be able to move forward. Okay? All right, well, if you need a business card, they're in the back, so feel free to stop by and grab one, and good luck with your projects, and hopefully I will see you all again soon. Thanks.